and I have been okay. Well, once again, now that we're being recorded, I'm introducing Ralph Wilmer, the AICP Ethics Officer, who is I wouldn't say the decider, but the moderator of most ethical issues that come before the American Institute of Certified Planners, and uniquely qualified to discuss private practice ethics with us today. Before I turn the floor over to Ralph, I want to mention how we got to this realization that we needed to have this conversation. And a very old friend of mine that I hadn't spoken with in maybe almost 50 years showed up on the roster of the private practice division, Mike Anake. And his career was spent mostly with ULI, and then he became the chair of the real estate department at Johns Hopkins University before he retired. And I said, well, how can planners make more money out of land development process? And it's a pretty simple question, but part of the answer was to point out that our peer professionals are paid more when the land development application that they are working on becomes successful. And Mike also pointed out that the greatest increase in the value of a piece of property will come from when it's rezoned to a relatively unimpactful use, if that's the right word, to one that's more, it calls for more intensive development. And he said, planners play a key role in that. And planners are in a better position to get a piece of property rezoned than someone else because they know more about the zoning process. But we tend not to get compensated in proportion to other professions, surveyors, finance people, whatever. They all get more money if the development is successful than if the development is not successful. And the key to that is contingent fees, which I believe poses an ethical problem for planners under the AICP code that it might not pose for an architect or an attorney or a real estate professional who is more accustomed to working with contingent fees. And that's the issue that I approached Ralph with at the National Planning Conference in Minneapolis. And I've been itching to hear from him ever since. So without any more ado than that, I'll let Ralph talk about why we can or can't do that. And just as a case study, I'd say, what happens if the applicant comes to a planner and says, okay, here's what I'm going to pay you. I'm going to pay you a lot in this subdivision once it's approved. I don't think that's ethical, but I want to hear Ralph tell us why it isn't.
Okay, well, thank you for inviting me to speak with you. I'll get to that issue in a little bit, but when you're first of all, let me just say by way of introduction that the majority of my career was also as a private sector planner. I worked as a non-legal employee as a planner in a law firm for a good number of years. And then I worked in a multidisciplinary firm that worked mostly along the Eastern Seaboard as a planner in a firm that specialized in engineering, land development, environmental, and transportation. So I've dealt with a variety of issues over the years, and I've served as the ethics officer now for 2 years. having succeeded Jim Peters, who held the position for 7 years. Prior to that, the AICP ethics officer was always the executive director of APA. That was part of that job description. But when we had our first non-planner executive director running APA, he decided at that point that he had no idea how to review and adjudicate these complaints and how to interpret the code. So that's when they hired the person who preceded me in this job. So before I guess I wanted to know, is there any need for me to do any kind of an introduction about the code, how it got to where it is, anything about the most recent updates to the code? I'll probably mention something about the 2022 update to the code, but just wondered how much I need to do in terms of introductory remarks. Any thoughts?
I think if you could sort of frame it in terms of how the code has evolved and the major aspects of the code as they relate to private practice planners. I think a lot.
Okay.
Please go ahead.
Okay. And I think a fair amount of that is covered in the Private Practice Handbook, most recent version. I did review the ethics chapter before it was published in its final form. So, I think it provides a pretty good background of some of the key issues that private sector planners might run into more often than others. But just by way of introduction, the code has been around for a good number of years. There are a set of principles that apply to all APA members. It's the APA Principles for Ethical Conduct, I think is what it's called. But that was generated in 1992. It hasn't been updated since then, but a lot of the provisions from that set of principles have morphed their way into the AICP code. The AICP code is divided into several sections, and as the Private Practice Handbook points out, Part A are the principles to which we aspire. So generally, those are the things that we encourage planners to do. And then Section B are the rules of conduct, which are generally the things that we encourage planners not to do. And I think there were three major aspects to the update that was adopted in November 21 and took effect in January of 22. One is that they were just reorganized so that they make a little bit more sense to people reviewing it. So it's broken up into 7 categories: quality and integrity of practice, conflict of interest, improper influence and abuse of position, honesty and fair dealing, your responsibility to your employer, discrimination and harassment, and cooperation with the ethics officer when a charge has been brought. The harassment and equity, diversity, and inclusion aspects of the code is another major improvement that has been made to the code to bring it a little bit more up to date with issues that we're dealing with, regardless of whether we're public or private sector planners. So I will point out that while there are some things that might be a little bit more relevant to private sector planners just because of the nature of the work that you do, they do apply across the board anyone who's an AICP member. And as the ethics officer, my jurisdiction begins and ends with AICP planners. So if a complaint is filed against someone and that person is not an AICP member, I have to dismiss the case. I have no jurisdiction. over that. And then the third major change to the code is that only AICP members can appeal a decision that's made by me as ethics officer. So prior to that, anyone could file an appeal. And you look at the types of complaints and the number of complaints that are submitted to the ethics officer every year. My guess is that roughly half of them are filed by citizens who are upset with a decision or a planning process that a planner has been involved with, and that's their attempt to try and seeking revenge might not be the best word, but their way of trying to get at the planner that they've had disagreements with. And what would happen is that a lot of those complaints were frivolous. They didn't have any basis either in reality, or that they didn't allege any behavior that was actually in violation of the AICP code. So the fact that non-AICP planners cannot submit a request for an appeal of a decision helps to cut down on frivolous complaints, and frankly helps to cut down on my workload. Just FYI, this is a part-time position, averages about 1 day a week. And I'm doing this across the board. So typically I would get about 10 calls for informal advice every month on average, and 2 to 3 complaints have to be investigated, adjudicated every month on average. And if you wanted to get a history of the types of cases and the numbers and what categories they fall into, if you just go to planning.org/ethics, the more information than you probably care to look at, but it does include the annual reports that give you a summary of what has transpired in the previous. So, just looking at the Private Practice Handbook, like I said, I think that a lot of the things are covered. I would say that the majority of the calls and cases that I get tend to fall into the category of conflict of interest. I think that a lot of that is pretty obvious in terms of how it would be interpreted. But we do get a lot of inquiries about people who, it's a fine line between a real conflict of interest and a perception of a conflict of interest. And what I always tell people when they call with questions, that there is a wild card that we have no control over. So I can provide whatever advice I think is the proper advice as to whether or not someone is in line with the AICP Code of Ethics, or whether they should take a different tact in addressing a particular problem. I would say that the wild card that's out there is that anyone can file a complaint. So even if you are doing everything that you should be doing and you're following the code, that doesn't mean that you're immune from a complaint being filed against you. So, and I think we see a lot more of that on the public side, just because of public-facing manner in which their work takes place. But I think it's an issue for all of us as planners. And we just have to be cognizant of the fact that someone could file a complaint if they so desire. So, one of the key issues that's highlighted very early on in that chapter is the change of position on an issue. let me back up one thing, one other point that I want to make about the code and a lot of calls that I get. And that is relating to potential conflict of interest as it relates to who our primary employer is and any changes that we have, whether it is an opportunity to join a local board or commission, and how you handle that, or even just an advisory committee within the town in which you live, and how you handle your role in that situation versus your responsibility to your employer, uh, which may mean whatever uh, um, contracted work you're assigned to work on, and things along those lines. So making sure that you avoid a conflict of interest in that respect. And then the other type of question that I tend to get a lot of inquiries on is the transition from either public sector to private sector or vice versa. There is no time frame in our code of ethics in which you know a public sector, if you work for the public sector and now you're working for the private sector, there's no time frame that excludes you from doing work within the community that you used to work in, assuming that it has nothing to do with the work that you did prior to joining the private sector. So there's no, 1 year waiting time or cooling off period like there might be for a legislator, or he or she can become lobbyist, for instance. But I also always caution people to double check with state rules and regulations, state ethics codes. If you need to, I'm in Massachusetts, and we have an ethics commission. And just like someone can call me for ethics advice, you can do that to the ethics commission as well. So just be cognizant of the fact that there may be rules or guidelines in place within the state in which you work that may override what I would tell you as it relates to the AICP Code of Ethics. But the only provision in the code that does have a time frame is this change of position on an issue. And I think that that is one that is particularly relevant to the private sector, because you're going to be working for different clients, whether they be public or private. You may be working within the same community. You may be looking at similar issues over time. And there is a 3-year time frame in that rule. That's rule number 19 of the code. And it says that you should not be advocating a position that is contrary to a position you took in a prior position, either a prior employer, or even if it's the same employer, but you're looking at the same issue, but come to a different conclusion. Of course, there are a couple of caveats because sometimes situations change, information becomes available, and there may be extenuating circumstances that justify a change in position, in which case you would have to identify what those changes are. But otherwise, there is a 3-year time frame under which avoid advocating for a position that is significantly different position you advocated for. The other issue that unfortunately I do have to address more often than I thought I would have to is plagiarism. And it should be a fairly simple thing to deal with. If you're citing a source, just acknowledge it. Then I don't get involved in these kinds of things. But I've had a couple of cases where through one means or another, the complainant has identified the fact that a report was written that includes verbatim material from another report and just never cited this, the source of the material. It's really just as simple as a footnote or an endnote or a parenthetical notation in the text of your report, and avoid talking to you about um, another issue that I tend to deal with that probably is a little bit more relevant to the private sector than the public sector is claiming credit for work that that was done by others. So, I think that there are situations, and I've seen it in my own practice or in my own career, where you change jobs and your firm describes experience that your firm has, and it may be for a particular kind of uh, um, project, but when you look at the company website, it lists, for instance, that you have expertise in open space and recreation plans. But if Joe Smith was the person that did those plans and no one else in the firm does that, and Joe Smith goes to another job, is it ethical for you to continue to purport that you do work and that your firm has expertise in doing open space and recreation plans? So I just caution you to think about that when you have those kinds of personnel transitions and the personnel involved had particular areas of expertise that may not be reflected elsewhere in your staff. Obviously, if you're working for a larger company and you might have multiple offices, that may uh, result in a different way of thinking about it. But if you're a 5 or 6 person firm and one of your key people left and he or she was the person doing open space plans, now you don't have that expertise anymore because that person has left. You should look to see how you address that in your firm applications. And then lastly, and this is true across the board, but I'm seeing it a little bit more on the private sector than the public sector, is misuse of the AICP credential. I have had to issue each year several cease and desist letters to people who have let their AICP membership lapse. It may be because of failure to pay dues. It may be due to the failure of the planner to maintain their CM credits. There may be any number of reasons why the AICP membership has lapsed. But if that's the case, you need to remove AICP from email signatures, LinkedIn, company websites, letterhead, reports that are being authored by the person who is no longer AICP, et cetera, et cetera. And we've had a couple of, I had one situation recently where a private sector planner, he actually let his membership lapse while he was working in the public sector. And I sent him a cease and desist letter. And he apologized for letting the membership lapse. It, was during the pandemic and he couldn't afford it anymore, blah, blah, blah. But he knew that I was aware that he was using the AICP credential without being a member any longer. And then I found out that he got a job in the private sector and he was still using the AICP credential. So presumably he used that as a way to get himself qualified for the position. I double checked before I sent a second cease and desist letter to see whether or not he re-upped his membership, and he had not. And I sent him a second cease and desist letter. I checked the website several times afterwards, and he was still holding himself out as AICP. And I contacted the CEO of the company. And the CEO of the company was very apologetic, and he immediately removed the AICP from the planner's bio on his company website and deleted AICP references across the board. I think he was the only land use planner, this staff. It was mostly an engineering firm. And 2 days later, I got an email from him apologizing again, and he terminated the employee. Because apparently that person held himself out as being AICP. He wasn't, and that's how he, that's how he got the
Uh-huh.
job. So that's a more serious misuse of the credential. It's not happy to hear that this person was terminated, although I was pleased to learn that the CEO of the company, who is a PE and understands credentialing and licensing, thought that that misuse of the credential was serious enough that he took that action. So I think that's really all I wanted to say up front. So now for the question that has been posed. And I guess I'm curious as to why you think that it is a potential violation of the code. I mean, it's clearly not the kind of thing that the code directly addresses in any way, shape, or form. And a lot of times I have to sort of read between the lines when I'm asked a question. But
Hold on.
I'm sorry.
I'm looking at where I thought that I was thinking of conflict of interest number 8 might be applicable, where there's a potential for additional gain beyond the what do you call it, agreed
Okay.
upon fee.
Well, I was wondering if you were looking at that one. When I look at that particular provision of the code, I'm uh, and the scenario that I more often would see is um, I get a number of calls regarding a planner who and it tends to be a little bit more on the public sector side, public sector planner who on the side is being asked by a private consulting firm to look at some to do some work maybe outside their jurisdiction, the planner's jurisdiction in terms of its primary employee. And so that's the kind of situation where you're getting compensation from another client or employer, and you need to be aware of whether or not there's any conflict. So in this particular situation, with this vision of the code, it's important to make sure that all parties have received disclosure of any particular additional employment and and getting and the last part of this says that you need to get written approval to do that kind of stuff. Do that additional work. That's how I look at that particular provision, more so than the issue of getting a bonus, if that's the correct way to look at it, for having completed the work satisfactorily or quicker time frame than was originally expected. And if you've seen this in different circumstances, happy to talk about it. My understanding in those types of situations is that it's part of a contract, and a contract with an engineer or an architect or whatever would stipulate that if, there was an expectation that the work would take X number of months, but if they do the work in a quicker period of time and it may be prorated, they would get a higher level of compensation for the quicker turnaround in completion of the project. The times that I have seen it, it has been part of a contract. And if that's the case, again, I'm not sure that there would be a conflict of interest if planners were able to do it. It is curious that, we play an important role in these, just as important a role as some of these other credentialed allied professionals do, but for some reason, these types of incentives may not be offered as often to the planning firm as they are to the engineers and architects.
Well, it's not so much engineers. I think they're under a similar constraint, but architects and attorneys are specifically rewarded, and anyone who's involved in financing a development, they all wait for the project to be approved and closed, and then, depending on the financial benefit to the client, they get a share of that additional benefit, where planners typically do not. So a planner's fee for working on a development application, and some of what I'm saying is secondhand, and I'm waiting to recognize Susie. I saw your hand up. But just looking at the history, my friend Mike Anacave said that, all these other professionals are getting some kind of a bonus after the project is approved and financed, and the planners are not getting that bonus. So, I mean, thinking backwards from that fact, so why aren't planners getting more money when a development is approved than other professionals are? And I think it might have to do with just the orientation of the profession. Attorneys get paid to change their minds, and we're not supposed to, technically we're not allowed to. I think that it might be more as fundamental as that.
And with attorneys, a lot of work that's done by attorneys is strictly on a contingent fee basis anyway.
Right. So, I mean,
so maybe we should restructure our contracts to do that as well.
Yeah, but I mean, would it be ethical? I mean, that's the question. I don't know. I don't think it would be.
And I don't know that it would be a problem. We obviously have to make sure that the work that's being done is being done in a way that is consistent with the code. So, what we want to make sure that we avoid, if we're in that kind of a situation, is that we are providing adequate, timely, clear, and accurate information, that we are doing everything we're supposed to do to make sure that there's a public discourse, that public discourse is fair, in accordance with the law, is open to everyone involved in the process, including underserved populations. And there is also a provision that says that we shall not accept work for a fee or pro bono that cannot be performed within the promptness required by the prospective client, or that is required by the circumstances of the assignment. So that's sort of the flip side, that we want to make sure that we're not over-promising in terms of the work we do, both in terms of expertise and in terms of the timeliness of.
Okay. Susie, you had your hand up.
Yeah. I think we talked about it probably last meeting or a while ago. I think attorneys, engineers, and architects, they do have a seal, or I would say they do have a license. In order to obtain that license, you have to go through so many hoops, board exams and all these things. So On the other hand, I think it's easy. I don't know, from my personal perspective, it's easier for them to get bonuses because not many people have that PE designation. You have to go through the exams, you have to go through the, interview and testing and all these things. So it might be a difference. I'm not sure whether that is the trigger for not having bonuses, but the professional seal is quite important.
It does carry a little bit more weight. New Jersey is the only state that actually licenses planners. And it's done pretty much with the AICP exam, but there's a lot of work that New Jersey planners cannot do or cannot sign onto in terms of final reports unless they are AICP. But that's just one state.
Yeah, and in the pre-qualifications for the Florida Department of Transportation, they recognize the AICP credential as a component, I guess you could say, of a pre-qualification statement. But going up against engineers, which a lot of transportation planners do,
Yep.
They're very quick to assert their monopoly, I guess you could say, on certain roles and responsibilities. And as a transportation planner reviewing a traffic impact study in Tennessee, the disgruntled engineer did take me before the Tennessee Board of Professional Engineers. And I said that, I pointed out that it was absurd that for her to allege that an engineer was the only person qualified to evaluate an engineer's traffic impact study. And in fact, I referenced the Planning and Urban Design Studies manual from the American Planning Association that explicitly said that a planner can review a traffic impact study. And I knew it was in there because I had written the damn chapter. So, but the board decided that they would split the difference, and they said I could continue to review traffic impact studies as a planner, but I couldn't advertise my firm as a firm that reviewed traffic impact studies, which is absurd. But it didn't really change anything. It was just a pissed off engineer more than anything. So anyway, that's my story. I want to throw this around because I know other people on this call have got more experience with land development and working on behalf of applicants for rezonings and so forth than I have. I'm a consulting planner, but my clients have almost always been in the public sector. So Stephen, I know you've got some land development work behind you. You got some question or insight on this? Are you there? Might have lost you. About Owen.
Oh, sorry, I was on mute. I was really interested in what other people had to say. I mean, I've never really had a problem with what you're describing, Steve. I do try to point out when ethic issues come up that both private planners and the developers that we may represent are obviously members of the public, right? I mean, in the broadest possible definition, we constitute that body of citizens that are affected by our code of ethics. And why is that? Is just because private capital, private expertise, arguably private knowledge contribute to the built environment. And why am I saying all this? Is our ethics, which were just described in terms of providing clear, accurate, timely information that is in the public interest, in my mind encompasses the kind of work we would do, whether we're doing for a private body or a public body. And then as long as we conform to that set of standards, I don't know why there would be any issue with precisely how it is we're compensated. If our representations are false in order to assure a contingency payment would then be received, then we're arguing about the kind of skills, knowledge, and information we're presenting, not about how we get paid. So it seems to me this is kind of a bifurcated argument or bifurcated discussion. Can we represent private clients, without violating ethics? And the answer is yes. If we can represent them accurately, correctly, and fairly, why should how it is we be compensated then really be an issue? In my mind, there is a connection, but it's a stretch to say that we can't be compensated on the basis of a successful completion of an assignment. So, as you know, Steve, others don't know this, a lot of my practice does relate to how things are funded or financed. And I have in the past been compensated on the basis of successfully assuring that a development has in fact received the financial resources necessary to proceed. So I would argue you can do your work without violating the principles. You must do the work without violating the principles. If you do that, how you get paid is kind of a contracting matter, not an ethical matter. And that's kind of my position on it. I hope that makes some sense.
It does, and I'm learning a lot from this conversation personally. And what I'm getting from it is that a contingent fee, while it may be much more common or maybe routine among engineers and real estate professionals, and not engineers, architects and attorneys, and it's not so common for planners, but perhaps it could be more common or used more often without violating the code of ethics. That's I may write in for a formal determination, Ralph, and see where it lands. But I know it's most planners do work in the public sector, and it might not even come up very often for that single reason.
Well, I
But
was going to add, Steve, I think that many planners do come to the private division after years of public experience, and I think they carry over certain, I'm going to say certain, either, I don't want to use the word biases, that's not the word I'm struggling with, but they come over with certain perspectives, perhaps biases is the right word, that says this is how we function. And I think that's a piece of baggage that could be cut loose. But I also, as I was talking about my work, I was suddenly reminded of a particular classification of work where I would never take a contingent fee. And let me be clear on that. And I know many planners that do, which I'm horrified, is I do a lot of legal work. So I support attorneys in rights-of-way issues and other matters involving development rights. And if I represent a public agency, I'm going to be paid on an ongoing basis, not whether the case is settled or proceeds in a successful manner for a particular litigant. I've had many private attorneys wishing to retain me on the same basis. And I find that to be horribly challenging in the sense that while the standards for prosecuting a case successfully should certainly be the same, the notion that you would be a totally disinterested third party offering expertise on a totally disinterested basis in my mind, seems a little bit suspect, when you're hinging on the successful outcome of a suit. So why am I bringing this up? Well, clearly plenty of private planners do that work that way. And if my other argument was correct, that if you do the work exactly the same as you would, it really then shouldn't matter whether I'm accepting a legal contingent fee any differently than I would any other. But in my mind, I do draw that distinction, and perhaps I shouldn't, if that makes any sense.
Well, I think part of it also is that in terms of the money to be made, there's more money to be made if the development is successful than if it goes nowhere. And I have written agreements with architects and attorneys, or an attorney anyway, where I set it all out and said, this is my fee and this is what you owe me when I'm done, and all of that. And then when it's all over, I don't get paid. And they explain it to me. He says, well, nobody gets paid until we go to closing. And I had one attorney, I gave her 3 hours of my time briefing her on every planning related issue to it was actually something to do with a railroad being converted into a commuter line. And I briefed her thoroughly, and she said, and then when she wouldn't pay me because the client really didn't care one way or the other about it. So I got stuck, and I took an architect to I filed a small claim against the architect because he wouldn't pay my fee because it wasn't they hadn't gone to closing, and I had an ironclad contract and everything, so I took it in. I drilled the guy and I got paid, but the guy told me he'd never, I was blacklisted or whatever, forever and ever. So there are practical issues involved also, but I didn't want to take up so much time telling my own war stories, and I know there are a couple of people here, and I just want to make sure I didn't miss anybody. Ed, what's your perspective on all this? You got anything you want to contribute?
Well, can you guys hear me? Hear me
Okay.
now? Hold on.
Yeah, I can hear you.
But now he's muted.
There you go. I didn't know if I was unmuted or not. It's interesting. I've been I do a lot of expert testimony work, and I've been jilted by clients that didn't win. I've been jilted by clients who won, and that's frustrating. So having a good collections attorney on board is important. But what I've started doing now is I take a retainer that I know is going to exceed my time, and I won't show up and I won't speak unless I get that check. And then I write it, and I'll send them back a refund at the end of the day. But at the same time, I write right in my engagement letters that I'm not promising any particular outcome. I make it clear up front that I'm not there to, in discussion, I make it clear with them up front that I'm not there to justify their position. I'm there to study the site or the development or whatever it is, and provide a third-party professional opinion based on the facts. And the facts may not support it. So, but if I do the work, you're going to pay me for that, even if I come at the end of my report and say this is a bad idea. And I've had a couple clients. It doesn't happen very often because most of them do a lot of due diligence before they hire me. But I have a couple that I've done that for, and they've actually appreciated that they didn't go down a rabbit hole and spend hundreds of thousands or millions of dollars more on something that wasn't going to work. But for the most part, nobody wants to hear that. So after getting screwed out of a few tens of thousands of dollars, I made it a point to write it area in my engagements that I'm, that the outcome of my study will come out when I finish the study, not before I started. And I think that's critical ethically to me to not go into anything with, and I've had people in the hearing room accuse me of just coming up with something random to support a use, and I'm not. I won't do that. And it doesn't matter who the client is, I won't do that. So it's you just got to sort of stand there and hold your ground on that, in my opinion.
Well, if they're doing it, they're going to accuse you of doing it. I mean, that's kind of my take on that. They, yeah. Anyway, what part of where's your market? What part of the country are you working in?
I'm primarily in Baltimore, Washington area, but I'll
Okay.
go wherever anybody wants me.
Okay. All right. Well, I haven't heard from we haven't heard from Stephen, Vince, or Bonique. Is there anything? This is a conversation, so I try to get everybody involved in one when we have one. Is anything you care to contribute to this?
This is the first time I've attended one of these, so I'm just listening and learning.
Okay, where do you work?
I am in Fresno, California. I work for a engineering firm, so we're building our planning division here.
Okay, do you
So-
do entitlement work at all?
Yeah, we do entitlements, CEQA, and long-range planning. We have both public and private clients.
Okay, all right. And Vince, I haven't tapped you on the shoulder yet. Would you like to introduce yourself?
Yeah, Vince Cotero. I work for a mid-sized firm in Southwest Florida called Baracco and Associates. Civil engineering and surveying is the bread and butter, and I'm the only planner on staff. I'm late career. I semi-retired last year. Most of my career, the large majority, has been public sector in the state of Florida, but I worked for two small firms prior to this, 20 years ago or so. We had issues with non-payment in one of those firms in particular, and the president and the executive committee of that firm placed liens. I don't remember if it was on what Florida law allowed at that time, the firm itself or any land they owned. And that caused problems, but it also helped in some areas, kind of like the experience you had that you were talking about with, blacklisted and that kind of thing. But I was fortunate enough to have government agencies as clients, and they always paid on time, including a county government where I served as planning director through the firm. And we didn't have issues there. The firm I work for now has a very long tradition, been in business just under 30 years of dealing with large development companies. So that have good reputations, and some government work. So we haven't come across that issue, but the topic that you were talking about is very interesting, because I thought about it myself. I don't know if the members of this firm that take them through the whole entitlement process at the end receive some kind of payment for that. My role is the more traditional that you would expect. My job mostly is getting people through the entitlement process with a land use change, a zoning change, a variance, a special exception, a conditional use, an administrative permit. So I do mostly the land use planning. But it stops there. It's just our fee. I don't think our firm has really taken it to the level that you started the conversation out with, but I could be wrong. I've only been at this firm 10 months, so I don't know about that. It's an interesting twist, but they do have a lot of repeat clients. So like they develop a subdivision, they come back and they do two more, and the firm is already working on those contracts before the other ones expired. So that's where I think the positive reputation comes in, because they get a lot of repeat clients.
Okay. Well, our overall objective as a division is to get planners a bigger share of the benefits from the work that we do compared to our peer professionals. And partly along those lines, and I'm going to use this to kind of close it out, I've gotten some comments that in the ethical case studies, the typical scenario has got the private sector, the consulting planners is sort of the Black Bart of the story, and we were hoping that we could maybe get a better a few case studies where we were the heroes instead of the villains, to put it that way. So that's just a general observation that sometimes you're in there and so is this public planner is led astray by some consultant who's enticing him into something that's not really ethical. So I just wanted to make a pitch for a case study where the private sector planner is the good guy, and instead of the what do you call it, the outsider. And in fact, I think a lot of times planners in the public sector are more likely to be led astray, if you will, by political considerations than private sector planners. And I wanted to make that pitch also, that we do have our reputation is how we have value or add value to the process. If we're completely malleable every time a new opportunity comes up, then what do they need us for? What do we need planners for? If a planner is going to change his mind, to suit us a given situation or opportunity, I mean, you just skip the planner. The planners are valuable to the extent that we do understand the public interest, and we do know the regulations, and we do know the benefits of planning, and we do know the benefits of zoning ordinances and comprehensive plans and all the things that are our bread and butter. And we are putting ourselves and the profession in jeopardy if we overlook those what do you call it, essential tools for successful planning. So that's a little spiel anyway, but stay tuned. Ron's not still on the call, but he'll join us next month and lead a discussion of planners and politics, and we can consider some of these same issues in a more purely political context. But this is the kind of work we do, and I know we all love doing it, and we just want to be more recognized and more successful financially and more satisfied professionally, for doing better work. And one of the things that we have to offer that people, nominal planners or people who call themselves planners, is that they don't have a code of ethics, and they can't claim to follow any ethical standards. So having a code of ethics that we follow is an essential component of raising the value of professional planners vis-a-vis what do you call it? I call them nominal planners, people who just use the political relationships and call themselves planners to make a living. So anyway, thank you, Ralph.
Just a couple of quick comments regarding what you just said, and just wrap up on the question originally brought us together on this. First of all, I do get a lot of calls from mostly public sector planners who are pressured politically to do things that they either know or feel are in violation of our code. They're asked to make a decision on a project or make reach some conclusion that's not supported by the evidence. And it puts planners in a difficult position because the person that's telling them to do it, whether it's a city council member or a mayor or whatever, are not bound by our code, but the planner is. And how do they deal with that? And sometimes it's, do you stick to your principles and say that the code applies and I'm not going to do it and risk losing your job? Or do you do what you're told, recognizing that you may be violating code? So planners have frequently put it, I shouldn't frequently, in terms of the types of calls I get, it's a common question or complaint that
Okay.
planners are being put in difficult positions. And then regarding the whole issue about compensation, in looking at that provision of the code that you asked about, it's my belief that it really relates more to, and the way it's written, I think that it relates more to planners being asked to do additional work above and beyond what their normal job description would entail, and whether or not that runs into a conflict. However, I will see if I can find out a little bit more about the legislative history of that. And if I come to a different conclusion, I will let you know.
Okay, that's number 8, right? That's the one we're
Yes.
talking. Okay.
Number 8.
All right. Okay. All right. Well,
Okay.
I hope maybe Ralph, given the way we've ended this one, that it'll be the beginning of the next one, because we'll be talking explicitly about planning and politics. And I know that Ron Littlefield, as a FAIC planner and the former mayor of a big city, would have a lot to offer in terms of that conversation.
That's why I wanted to add that little bit of context.
Okay. All right. Well, hopefully we'll see you all and a bunch more next month. And Vince, if you're stuck in a hurricane somewhere, my heart goes out to you. But Jacksonville, we got away with it this time. I'm not sure how about Southwest Florida did, but
where I live, we were spared flooding, some road flooding, but we didn't have a lot of damage to structures this time.
okay. Wow. All right. Okay. Well, take care, and hopefully next week will be a little more conducive, at least weather-wise, to getting more people out. But thank you, Ralph. This has been enormously helpful to me and to the division as a whole. Take care.
Very good. Take care.
Thank you. Bye-bye.
Bye.
Bye.